Caitlin, what are you seeing right now? What stood out to you as you've had some more time with it?
Well, Phil, as Ellie is saying, one of the things here is that the prosecutors really are trying to refocus this around the private things that Donald Trump was doing, either as a candidate or working with people who were private citizens at the time of the election and after the election. And one of the things that this refocusing of the charges looks like is that it focuses on how Donald Trump was using people in battleground states, Arizona, Michigan, Georgia, et cetera, to try and change electoral votes or deceive the state people, the people in the legislators in those states. One of the things, too, that the prosecutors have to do here is they have to be able to show how Donald Trump was doing this. And one way they want to do it is with his Twitter account. Now, they have to walk a really fine line here, and this is the sort of thing that could very well be adjudicated with the judge, that they're going to need to talk about related to immunity because he was president at the time. And they have to write in here, here's a quote, "The defendant, Donald Trump, continued to make false claims nonetheless with deliberate disregard for the truth, including through his Twitter account." So that's the allegation. And they say that although he was sometimes using his Twitter account to communicate with the public as president about official actions and policies, he also regularly used it for personal purposes, including to spread knowingly false claims of election fraud and try to get his supporters to travel to Washington, D.C. So there you see the two sides of the coin that the prosecutors are going to have the judge look at and come down on their side to say, yeah, if we go to trial, we want to be able to use things that Donald Trump tweeted from his account on Twitter while president, but we want you to decide that those are personal things he was doing as a candidate and not as the president.
Okay, Caitlin Polantz, stand by. I do want to bring back in CNN's Kristen Holmes. Kristen, I guess the biggest question right now is how would Trump and his allies view this and respond to it in the minutes, hours, days ahead?
Well, right now we know the lawyers are going through this document, trying to parse through every word and figure out exactly what this means moving forward. Now, I think the big question, and this is something that we know has been going on really for months now, is what does this mean for a potential trial? When I talked to his advisors, when I talked to his legal advisors as well, the biggest concern among all of his legal cases, obviously, except for the one that it was actually brought to trial, but among the other three, was about this January 6th case and whether or not the judge would bring this ahead of the election. As we have routinely reported, Donald Trump's team and their strategy was to delay as much as they possibly could all of these legal matters till beyond the election, particularly the documents case, which has now been thrown out. I know there has been pushback on that, but as well as this January 6th case, because the idea being Donald Trump then would win the election and could get rid of these cases as they would be brought in his Department of Justice. Obviously, a lot of things would have to happen for that to happen. Donald Trump would actually have to win the election, and these cases would have to be delayed past that. Now, obviously, in terms of the documents case, that's not happening before. There's going to be no trial or anything before the election. But the biggest concern has been this January 6th case. The judge has said she wants to move quickly on it. So the question now is, what are the next steps the lawyers are going to take to try and ensure that there is nothing that happens on this case in terms of a trial before that November 5th election? Because again, that has always been their biggest concern, was that they might have to face this before voters actually cast their ballots. Now, I will tell you from speaking to a number of his advisors, legal advisors, they don't think that there's anything that can happen in terms of a trial before the election at this point, that things have just been delayed so far back. But that doesn't mean that they are 100% certain about that. So as they go through this, we are waiting for a formal response from both the legal team and from the political team. Often they are one. We will see who puts out the actual statement. But the concern has always been, what does this mean for a potential trial ahead of November 5th?
All right, Kristen Holmes, we'll let you get back on the phone to your sources. We wait for an official response from one side or the other in the minutes and hours ahead. Let's go back to CNN's Caitlin Polantz. Caitlin, as you kind of walk through this, and I was struck in listening to Kristen kind of walk through, you think about the documents case down in Florida, which was dismissed, has now been appealed. We don't really know where that's standing, but it's clearly not moving forward in an expedited fashion. There's this case as well. We obviously are still waiting for the sentencing, which has been postponed in New York on the felony charges. The president was convicted, former president was convicted of. Fulton County still has its case as well. As you continue to go through this, what more are you learning?
Phil, there is a fascinating part of this superseding indictment that was a big question. How much, if the Justice Department wanted to move forward with this case, how much would it still revolve around Mike Pence, the vice president? This was something that the Supreme Court did not give a clear answer on, and basically said the lower courts were going to have to figure out how much of the interactions between Donald Trump as president and Vice President Mike Pence at the time would be falling under immunity, something that could very well end up back at the Supreme Court. And from what I'm seeing here on these pages, there are several pages that document Donald Trump's interactions with Vice President Mike Pence as part of the key allegations in bringing these charges against Trump and continuing them on. That means they want Pence to stay part of this case, and they very likely want him to stay a potential witness in this case. The way that they're trying to walk this line is they're articulating dates when Donald Trump and Mike Pence either met in person or had conversations about what Pence was to do as president of the Senate. So a different branch of government than what Trump and Pence were doing as president and vice president. And so they're very likely going to be putting that before not just Judge Chutkan in the near future, but also very likely appeals courts, even potentially the Supreme Court ultimately on this question. What Mike Pence and Donald Trump talked about every time Trump was berating him, turning the conversation with him to January 6th, telling him what he wanted him to do to block the certification of the Electoral College votes when Pence would preside over the Senate session. All of that is very likely going to be something the prosecutors are going to fight to keep in this case. And Donald Trump's team is going to try and argue, we don't want Pence here at all.
Caitlin, real quick, because I know you still have a lot more to go to, but essentially there was, and I'm going to shorthand here, and I know we're probably going to have Joan Biskupic, our Supreme Court expert, on in a little bit, who will explain this in a much more eloquent way than I can. But there was a roadmap laid out on unofficial acts, non-presidential acts, if you will, by the Supreme Court that Jack Smith and his team could try and follow, which would essentially lead to challenge accepted. Here are the things that we're now going to put up, and you can tell us whether or not judges here or there, whether or not these are official or unofficial acts. And that's essentially what's happening here, right?
Yeah, and one of the things that the Supreme Court said was they were very clear. If Donald Trump was giving orders to somebody beneath him in the administration, that can't be part of the case. Right. That gets protected. And that is what they clearly cut out here. This is the discussions between Donald Trump and Jeffrey Clark at the Justice Department, pressuring him to go to Georgia or to put pressure inside the Justice Department. But that's something that was easily removed, apparently. And the Supreme Court was not as clear about what to do with all of these interactions between the president and the vice president. And then on top of that, the Supreme Court ruling said, you're going to have a hard time using some of this stuff as evidence in a case too. Maybe you can cut it out of the formal pieces of what you can charge, but they also are expanding what they said and said, we don't want some of these things that could be immune at trial. Now, the Justice Department, has always been something since that Supreme Court immunity came down, where people have wondered, how would they take a case like this to trial? Would they even be able to get the witnesses and the evidence that they wanted into a court before a jury if they do take Donald Trump to trial? And it does look like they're going for it. They're going to want and they're going to need to have someone like Mike Pence on the stand, not just people around Donald Trump in his campaign or in state governments, state electors, fake electors, that they do want Pence and the interactions there to be documented before that jury. That is something that is very likely going to have to be looked at by the courts again, once, maybe twice, maybe three times or more. Who knows, Phil?
Yeah, and maybe even more than that. It has been the central question since the immunity ruling as it relates to this case is how is Jack Smith and his team going to try and reshape this in a way that they think would work? How far are they willing to go trying to push kind of the levels of ambiguity involved in that decision? We now have our answer. Special counsel Jack Smith just filed a superseding indictment in the federal election interference case against former President Donald Trump. Let's bring in criminal defense attorney Bill Brennan, former lawyer for the Trump Organization. Elie Honig joins us as well. Bill, to start with you, what do you make of the decision to move forward with these slimmed down charges in this superseding indictment?
Hello, Phil, Elie, how are you? Phil, it's not uncommon for a prosecutor to do this. It's actually a smart move with the trouble that he's having with the now former, but as of an hour ago, current indictment. He now supersedes, he streamlines, and he tries to take that indictment further. I mean, it really is a smart move on Jack Smith's part. Whether it'll survive is unclear right now, but it is a slick move.
To that point, how do you think Trump world would react to this now that it's out?
I think that the former president's lawyers, who are all very competent, will file motions saying we've basically got the same old indictment shined up purportedly as something new, that this case has been ruled on already, that this shouldn't change anything. And it really probably will come down to whether or not what's remaining in the superseding indictment is outside the perimeters, the heartland of the Supreme Court's recent ruling on presidential immunity. I mean, that's really where the rubber hits the road here. If there are charges that bring in presidential immunity, it's going to be a problem for Mr. Smith. If there are charges that don't go into that territory, then he may survive.
Ellie, to that point, is this just inevitable that this case ends up back at the Supreme Court on some of those questions?
I think it is inevitable, Phil. And here's what's going to happen from here. As Bill said, what we have here now is a superseding indictment. So it replaces the original indictment. The original indictment was about 45 pages. This new one is about 36 pages. And what DOJ has done is take out those items that the Supreme Court specified are now clearly covered by the immunity ruling. Most obviously, the allegations that were in the original indictment relating to Trump's effort to pressure DOJ, those are gone. Those are essentially deleted out of the new indictment. The allegations relating to Mike Pence remain in the new indictment. They're changed a little bit. As Caitlin said before, they're sort of more focused on his role as president of the Senate than his role as vice president. But here's what's going to happen next. They're going to go into court within the next few weeks. Donald Trump's team is going to say, great, they got rid of the DOJ stuff. We agree with that. But we also think everything that's still in the indictment should be immune as well. Judge Chutkan will make a decision. If Donald Trump loses that, he'll appeal to the Court of Appeals. And then if he loses that, he'll try to get it back to the Supreme Court.
Let's bring in CNN's Kristen Holmes, who is covering the Trump campaign. So, Kristen, Trump just posted on his social media platform, Truth Social, about the indictment. What did he say?
I mean, it's more like, what did he not say? This is a real novel here. He posted on Truth Social, probably longer than, or at least the same length of the indictment himself. But essentially, he does a lot of the greatest hits. He says that this is an effort to resurrect a dead witch hunt in Washington, D.C. He calls it an act of desperation. He refers to Jack Smith as deranged, something he has done multiple times in the past. He calls it a ridiculous new indictment. And then he goes on to talk about how the Florida case was dismissed. I think probably the most interesting part about this, but not surprising, is the fact that he has officially moved over to the fact that this is election interference on the side of Kamala Harris. Obviously, we heard for months and months and months about how this was, quote unquote, Biden election interference. Now, obviously, he has a new opponent, and now it is Kamala Harris's election interference. And I will tell you that he is getting briefed on this by a lot of his own legal advisors, because I spoke to some of them earlier today who said the exact same thing. They are angry at the fact that this was brought so close to the election. I will say this is the one line I'm going to read. This is now Kamala's weaponized system against her political opponent, something we've heard before, Alex.
All right, Kristen Holmes with the Trump response to this revised indictment. Thanks very much. Joining me now are our legal experts to break this down even further. Joan Biskupic, I want to go to you first because so much of this comes back to the Supreme Court. They're ruling in early July about presidential immunity. How is Jack Smith now with this revised indictment trying to get around what the Supreme Court said?
Sure, Alex. And, it's a strong recasting of the original indictment, but there are hurdles ahead simply because of the way Chief Justice John Roberts, who wrote for the majority, described official acts. Remember that he drew a line between official and unofficial acts and said for anything that was official, there would be a presumption, if not absolute immunity. So that's why it's so important, the distinction. And then he expansively defined what would constitute an official act, essentially saying just about anything within the outer perimeter of a president's duties. So it's a very expansive definition that he writes of official acts. Now, I should say that one of the individuals in that majority, Justice Amy Coney Barrett, she wrote a concurring statement that tried to give a path forward and to say, look, this really, when all is said and done, is sort of narrowly construing the kind of immunity that would be here and giving a little bit more of a roadmap. And I think that if that Jack Smith has done all he can to say that so many of these actions that would amount to election subversion in his mind actually were taken as candidate Trump, and is trying to make that case as strong as possible. And I think that someone like Justice Barrett would go for it. Maybe the chief in the end would. But I just want to remind people also what the dissenters said when they saw the chief's standard. Justice Sonia Sotomayor, writing for the three liberal dissenters, said that the way the chief and the majority had construed the dividing line between unofficial and official acts, it reduced unofficial acts to almost a nullity.
Andrew McCabe, what stands out to you looking at this revised indictment? How effective do you think this argument by Jack Smith is going to be?
It's remarkable, Alex. I think this is basically Jack Smith saying, I still got this, right? He's basically sanitized the original indictment a bit. He's taken out those things that Joan mentioned that were clearly called out in the Supreme Court decision as being well within the scope of official acts. He's dropped the DOJ stuff. He's also made an effort to characterize the other co-conspirators, not co-conspirator who we believe was Jeffrey Clark. He's been notably left out. But the other co-conspirators, he's characterized them as private attorneys or consultants, really kind of trying to cabin people off into these non-official, non-government roles, which I think is accurate. Remarkable to me that he's left in the 1512 C2 count. That was the count that the Supreme Court addressed in the Fisher case that came out just before the immunity decision. Many people thought that he might have some trouble keeping that count in. Clearly, Jack Smith believes that the indictment is built around enough pieces of evidence, specifically the fraudulent elector ballots, that will help that count survive. So he's really not taken a lot out. He's brought the same very strong case. We'll see what happens after it goes through this process with Judge Chutkan and the Trump attorneys to determine specifically what evidence remains at play.
So, Jennifer Rogers, it appears that what Smith is trying to do here is to take a lot and put it outside the orbit of the office of the presidency. The special counsel arguing also that the former vice president, Vice President Mike Pence, that his role in certifying the election results was ceremonial, not part of his duties as vice president. Do you think that's going to work?
Yeah, that's the big question. That, to me, is the thing that's closest to the line. Was he wearing his hat of vice president, or was he wearing the hat of the president of the Senate when this pressure campaign was going on? That's where I think Jack Smith may have the most trouble on appeal, and even perhaps initially with Judge Chutkan, in where that conduct falls. Otherwise, I think they've done a good job of kind of laying out the official versus unofficial. But I agree with your observation, Alex. This really is the thing where I think they might have the most trouble. And, we're at the starting line. So Judge Chutkan will have the first crack after Donald Trump and his lawyers move to dismiss this indictment at saying whether this new superseding indictment passes muster or not. They may have to go back to the drawing board on that very issue that you point out. But we're at the starting line, and we'll see now again what happens as soon as this is under consideration by the court.
In terms of those risks that Jennifer just mentioned, Ankush Khardori, what dangers do you see in this new approach by Jack Smith?
Well, look, I think he actually took what I would view as a relatively conservative approach to interpreting the Supreme Court's decision, and I think the right approach in terms of drawing the lines that the Supreme Court has asked them to draw. Remains to be seen, as everyone has noted, how the judge will move forward here. I mean, look, the risk here is it originated with the Supreme Court. The Supreme Court created an entirely new test. It is a nebulous test, as folks here have already noted, hard to sort of wrap your arms around. And they didn't do a particularly good job of explaining to the parties or the judge what types of evidence should be adduced to kind of figure out what sort of conduct is on the official side versus the unofficial line. So I think, Jack Smith and his team have done a good job here, but there's still all this uncertainty that emanates from the Supreme Court's decision that has really put this case in limbo, sort of mostly between now and November. We'll see if Jack Smith wants to move forward with some evidentiary hearings. I think that would be a good idea because I think the public wants this information. But I think it's just important as we sort of think about this to recall that, this is a very big year. This is a very important election. This case is at stake in the election because if Trump wins, it's going away. If Trump loses to Harris, this case is going to proceed to some sort of conclusion.
And we did just hear part of Trump's outrage, Elise Adamson, from our Kristen Holmes. He was posted on Truth Social. How do you think the Trump legal team needs to be thinking about this? Is this in some ways a win, or do you see this as a loss for him?
Look, I think it's kind of yet to be determined because we have to see how Judge Chutkan ultimately rules on this superseding indictment. Because after the Trump team moves to dismiss the indictment, which we expect they will, then to Ankish's point, they're going to have evidentiary hearings, or at least a hearing on whether or not the judge agrees with the special counsel's office framing of a lot of these acts as official or unofficial acts. If Donald Trump prevails on those arguments, then I think it would be considered a win for him. If he loses, well, then clearly he will take that as a loss. Although I think we can expect to see an interlocutory appeal goes back to the Supreme Court, and that it might ultimately be a win. Today, he's thinking of it as a loss because it's making headlines. It's not what he wants during this election season, and this case is still alive. But ultimately, how it pans out, it's yet to be seen.
Yeah, certainly a lot more to come in this case. A lot of new details in this, a remarkable move by the special counsel. Thank you all for joining me.
And thanks. Joining us now to drill down further is former federal prosecutor and best-selling Supreme Court biographer Jeffrey Toobin and CNN legal analyst Norm Eisen, who wrote in the wake of the immunity decision by the Supreme Court that Jack Smith would have to follow what he then called a slim-to-win strategy to preserve his chances of prevailing in the case. Joining us as well, CNN senior political commentator and former January 6th Select Committee member Adam Kinzinger. Jeff, what's your reaction to this revised indictment? Does it make sense?
Well, he had to do it. The old indictment just didn't pass muster at the Supreme Court. And the key distinction here is the Supreme Court said that official conduct for the president, by the president, can't be the subject of a prosecution. It can only be unofficial conduct. So the indictment tries to portray Trump as candidate Trump much more than President Trump. Now, the distinction between official and unofficial is not all that clear, and I think that's going to be something that comes up a lot. But the real theme of what Jack Smith did today was to try to make this an indictment of Donald Trump for his unofficial acts. That's what the parties are going to be fighting about in court starting next week.
Norm, what additions in this indictment stand out to you?
Anderson, the subtractions stand out more than the additions. We've gone from 130 paragraphs to 106, from 45 pages to 36 pages, and he's mostly removed allegations about the interactions of Donald Trump with DOJ. Whatever you think of the Supreme Court's opinion, there are few things that are more official than a president talking to his Department of Justice. But there are important additions. It starts on the first page. It used to say the defendant disseminated falsehoods. Now it says the defendant used his campaign to disseminate falsehoods. And you see those modifications on page after page where they're adding those phrases to narrow, as Jeff notes, the scope here, tightening it down. I don't think that you can quibble with Smith's effort to slim this indictment down. I do think he has a strong hand and he's playing it.
Congressman Kinzinger, I mean, as a former member of the January 6th House Select Committee, how do you look at this revised indictment?
Well, just like the others, I mean, it had to be done. Not a surprise. I guess I'm fairly pleased that none of the charges were dropped. None of the actual charges, just kind of had to change what was backing it up. But I mean, the crazy thing about all this is, first off, if you think about the Supreme Court decision, they did not really go into much specificity about what is unofficial or official acts. So what I can see, and the lawyers here would be smarter than me on this, but I could see this basically every charge in essence almost having to go up to the Supreme Court because they did not do their job, except that the Chief Justice said to the outer limits, whatever that means. I mean, that's another thing up for interpretation. Amy Coney Barrett kind of gave a little specificity when she said the fake elector scheme wouldn't count. But it just, for a Supreme Court to have created such a big precedent and not put any meat on those bones, this is going to drag out. I think the bottom line here, Anderson, is November. I mean, it's all about November. If Donald Trump wins, obviously there is no way this goes forward under his Justice Department. If he loses, then we have to go through a bunch of more hoops. But justice will be had. But it'll be nice, by the way, someday, whenever that is, maybe it's like months, maybe it's years, when former presidents quit using Twitter or Truth Social to emote every day about their anger and just maybe go back to using statements again like adults do.
Jeff, what about the congressman's points? I mean, what does this actually mean in terms of, does this go back to the Supreme Court for each of these things?
Well, this is an absolutely critical issue that the parties are going to fight about. The usual rule in criminal cases is you only get to appeal after a conviction. You can't appeal before the case is over in the district court. On this issue of presidential immunity, Trump was allowed to appeal to the DC Circuit and then to the Supreme Court. That's why this indictment is 13 months old and there's no trial in sight. The big issue upcoming is presumably Judge Chutkan, she's the district court judge, is going to say that some version of this case can proceed. The key question, which is unresolved, is will Trump be allowed to appeal before the trial again? Because if he is, that could mean another 6 months or even more of delay. If he's not allowed to appeal, there could be a trial in early 2025. Of course, that depends. That will only happen if Harris wins the election.
And who decides if he can appeal or not?
Sorry?
Who decides whether Trump can appeal or not?
The courts themselves. I mean, the issue will be.
I mean, is it Judge Chutkan?
Well, first it will be Judge Chutkan, but then that decision of whether he can appeal will be appealed itself. So, I mean, this again, the defense lawyers have done a very good job of putting this case on a slow boat to nowhere. Yeah. And for the moment, that's where it remains.
Norm, what do you make of how prosecutors have reframed Vice President Pence in this indictment?
Well, historically, Anderson, the vice president is also the president of the Senate. That's spelled out in the Constitution and backed up by long practice. He's not an official executive branch actor if he's in conversations or taking action on behalf of another branch of government. So I think it's legally sound. It fits into their larger strategy here. They are signaling that they continue to have a strong case. To the congressman's point, this now goes to the court of public opinion. We will have proceedings, we will have attention on this, but ultimately the American people, because the Supreme Court took so long to decide and because their decision was so bad, it is now up to the American people whether or not Donald Trump is going to face a jury on this very strong complaint. And I think no wonder Donald Trump is mad, Anderson. By doing a superseder, they put that question to the jury of the American people.
Yeah. Norm Eisen, Jeffrey Toobin, Adam Kinzinger, thanks very much.